I was sitting on my dock watching the sunrise over Lake Tahoe when I noticed the first construction crew pulling up to my shoreline with enough lumber to build a small village. That was the moment I realized my life was about to become incredibly complicated, though I had no idea just how profitable that complication would turn out to be. My name is Marcus Webb, and I own a 12-acre lakefront property on the Nevada side of Lake Tahoe that I inherited from my grandfather 3 years ago. The property includes about 800 feet of pristine shoreline, a main house built in the 1960s, and enough land that I occasionally forget where my property lines actually end. I work remotely as a software consultant, which means I spend most of my time enjoying the view and occasionally answering emails. Life was peaceful, quiet, and exactly what I needed after burning out in Silicon Valley. That peace shattered on a Tuesday morning in late March when I walked down to my dock with my coffee and found a woman in her late 40s standing on my beach with a clipboard, a hard hat, and an expression that suggested she owned the place more than I did. She had that distinctive haircut, the one that tapers short in the back and angles forward at the sides, and she was wearing a blazer despite the early morning chill suggesting she meant business. "Excuse me," I called out as I approached. "Can I help you?" She turned to me with a smile that did not reach her eyes. "Good morning. I am Barbara Hutchinson, president of the Pine Ridge Homeowners Association. You must be Marcus Webb." "I am," I said, immediately suspicious, "but I am not part of any HOA. My property predates all the developments around here." Barbara's smile widened, which somehow made it even less friendly. "Actually, that is where you are mistaken. When the Pine Ridge Estates development was approved in 2019, the county required certain shared resources to be managed collectively. Your lakefront was designated as a common amenity area for all residents of Pine Ridge Estates." I nearly spit out my coffee. "That is completely insane. Nobody can just designate my private property as a common area." "Well, apparently they can and did," Barbara said, consulting her clipboard. "We have been paying the fees associated with maintaining this shoreline for the past 3 years. You should have received notices." "I never received any notices about anything like that," I said, my voice rising. "And even if I had, that does not give you the right to just show up and start building things on my land." Barbara sighed as if I were a particularly slow child she was forced to educate. "Mr. Webb, perhaps you should consult with a lawyer about the specifics. In the meantime, we have approval from the county to construct boathouses for our residents. 53 families paid significant deposits for these slips, and construction begins today." "Like hell it does," I said. "Get off my property right now or I am calling the police." "Call them," Barbara said pleasantly. "I have all the permits right here. We are completely within our legal rights." I did call the police. Deputy Morrison showed up about 45 minutes later, looking like he would rather be anywhere else. He examined Barbara's permits, looked at the property documents I hastily printed out, and basically shrugged. "This is a civil matter," he said. "You two need to work it out in court." "As long as she has permits from the county, I cannot stop the construction." "But it is my property," I protested. "Then you need to prove that in court," Morrison said. "Until then, my hands are tied." Barbara gave me a triumphant smile as the deputy drove away. Within an hour, 3 construction crews arrived and began marking out locations along my shoreline. I stood on my deck, phone in hand, watching in disbelief as strangers started building structures on land my grandfather had owned for 50 years. I spent the rest of that day calling lawyers. The first 3 I reached told me essentially the same thing. I needed to file an injunction to stop the construction, but that would take weeks to get before a judge, and there was no guarantee I would win. The 4th lawyer, a sharp-eyed woman named Patricia Gomez who specialized in property law, told me something different. "Do not stop them," Patricia said. "What do you mean, do not stop them?" I asked, confused. "Let them build," she said. "If they are really constructing on your property without proper legal authority, then anything they build becomes your property." "You mentioned they collected deposits from homeowners." "That is what Barbara said, 53 families. And these are boathouses, essentially rental slips." "I guess so," I said. "Then let them build. Document everything. Keep records of every interaction. And in the meantime, I will quietly research the actual legal status of your property. If I am right about this, they are handing you a very lucrative gift." I was not sure I understood Patricia's strategy, but I trusted her confidence. She had been recommended by a former colleague who swore she was the best property attorney in Nevada. So I did what she suggested. I documented everything. I took photos, videos, and kept detailed notes of every conversation. I watched as Barbara and her crews spent the next 3 months transforming my peaceful shoreline into a bustling marina. The boathouses they built were actually pretty impressive. Each one was a covered slip with electrical hookups, water access, and storage lockers. They put in floating docks, installed lighting, and even added a small clubhouse at the northern end of my property. The construction cost must have been astronomical. I later found out that each family had paid a $15,000 deposit for their slip, plus monthly fees of $400 for maintenance and utilities. Do the math on that. 53 families times $15,000 equals $795,000 in deposits alone. The monthly fees added up to $21,200 every month. Barbara and the Pine Ridge Estates HOA were running a serious money-making operation on my land. I kept my distance during construction. Barbara would occasionally stop by the house to inform me of various rules and regulations I was now supposedly subject to. I could not have boats on the water during certain hours. I could not fish from the docks they had built on my property. I needed to keep my grass trimmed to HOA standards. Each time I would nod and smile and agree to everything, all while my phone was recording in my shirt pocket. Patricia worked quietly in the background. She discovered that the county designation Barbara kept referencing was based on a clerical error. Someone had transposed numbers on a property survey, and my land had been incorrectly listed as part of the Pine Ridge Estates development boundary. The error should have been caught during the approval process, but it had slipped through. More importantly, I had never been properly notified of any hearings or decisions, because all the notices had been sent to an old address my grandfather had not used in decades. "We have them," Patricia told me in early June. "The designation is invalid. Your property was never legally part of the HOA's jurisdiction. Everything they have built is on your private land without your permission." "So what do we do?" I asked. "We could file for an immediate injunction now and have everything torn down," Patricia said. "Or we could play the long game." "Tell me about the long game," I said. Patricia smiled. "They have been operating these boat slips since Memorial Day weekend. They have been collecting those monthly fees. They have been telling residents this is all legal and proper. If we wait until the end of summer, until everyone has used and enjoyed these facilities all season, then we move to evict them, we have a much stronger position. They have been trespassing on your property for months. Everything they built becomes yours. And legally, those deposits they collected, those were for access to facilities on your private property. Facilities that the HOA had no right to offer. Can I keep the deposits?" I asked, not quite believing what I was hearing. "That is murkier," Patricia admitted. "But the HOA certainly cannot keep them, since they defrauded these homeowners by selling access to property they did not control. You would have a strong argument that since the structures are on your land, any funds collected for their use should rightfully be yours." At minimum, you could claim enough to cover the value of the land use and the disruption to your property. I thought about it for about 3 seconds. Let's play the long game, so I waited. I watched as the residents of Pine Ridge Estates enjoyed their summer on my lakefront. They launched their boats, held barbecues in the clubhouse, and generally acted like they owned the place. Barbara strutted around like she had personally created a paradise, making sure everyone followed the extensive rules she had posted everywhere. I kept documenting everything. I photographed every boat, every family, every event. I recorded Barbara's increasingly aggressive demands about my own behavior on my own property. In July, she actually tried to fine me $200 for parking my truck in a spot she claimed violated the sight line regulations. I paid the fine with a smile and a recording device in my pocket. The homeowners themselves were mostly nice people who had no idea they were caught in the middle of a property dispute. They thought they had legitimately purchased access to these facilities. They invited me to their events, offered me beers, and generally treated me like a neighbor. I felt a little guilty about what was coming, but they had paid their money to Barbara and the HOA, not to me. If anyone was defrauding them, it was Pine Ridge Estates. August was when Barbara really ramped up her tyranny. She started issuing violations for everything. One family got fined because their boat cover was the wrong shade of blue. Another got hit with a $500 fine for having guests over without prior approval. She tried to institute quiet hours from 8 p.m. to 8 a.m., which was absurd for a lakefront recreation area. People started grumbling, but they paid their fees and followed the rules because they had invested so much money in their deposits. Barbara called a mandatory meeting in mid-August to discuss ongoing compliance issues. I was not invited, but I showed up anyway. About 40 residents crowded into the clubhouse, and Barbara held court like a queen addressing her subjects. "We have worked too hard to create this beautiful facility to let standards slip," she announced. "Some of you seem to think the rules are suggestions. They are not. This is a premium amenity and we will maintain premium standards." A man in his 60s raised his hand. "Barbara, some of these fines seem excessive." $500 because my grandson left a toy on the dock. The rules clearly state that all personal items must be stored in the provided lockers, Barbara said. No exceptions. "But he is 7 years old," the man protested. "Then perhaps you should supervise him more carefully," Barbara snapped. "The fine stands. Anyone else have questions?" I watched the frustration build in the room. These people had paid nearly $1 million collectively for the privilege of being hectored and fined by Barbara. I almost felt bad about what was coming. Almost. Labor Day weekend was the unofficial end of summer. The lake was packed with boats. Families were having one last hurrah before school started, and the Pine Ridge Estates marina was at full capacity. Barbara organized a big end-of-summer party on Sunday, complete with catered food and a live band. She gave a speech thanking everyone for their cooperation and reminding them that monthly fees for the off-season would continue, although at a reduced rate of $250 per month for winter maintenance and storage. I attended the party. I shook hands, ate Barbara's catered shrimp, and smiled at everyone. Barbara actually came over to talk to me, which she rarely did. "I am glad you have finally accepted the situation," she said. "I know the transition was difficult, but this facility really does benefit everyone, including you." "Oh, I have definitely benefited," I said honestly. "This summer has been very educational." She smiled her shark smile. "I am glad you see it that way. Now, I have been meaning to talk to you about next year. We are considering an expansion, possibly adding another 20 slips on the southern portion of our shared shoreline. The engineering surveys should begin in October." "That sounds ambitious," I said. Go big or go home, that is my motto, Barbara said. This facility has been such a success that we have a waiting list of 17 families who want slips. It would be financially irresponsible not to expand. I nodded thoughtfully, already imagining Patricia's reaction when I told her about this conversation. Well, I am sure you know what you are doing. I always do, Barbara said confidently, then wandered off to micromanage the caterers. The Tuesday after Labor Day, Patricia filed a lawsuit in Washoe County District Court. We sued the Pine Ridge HOA, Barbara Hutchinson personally, and the 3 construction companies that had built the facilities. The lawsuit laid out everything: the fraudulent property designation, the lack of proper notice, the unauthorized construction on private land, and the collection of fees for access to facilities the HOA had no legal right to offer. We also filed for an immediate restraining order and injunction, demanding that all residents remove their boats and property from my land within 30 days. Patricia included 57 pages of documentation: property records, surveys, photos, videos, and recordings of conversations with Barbara. The process server delivered the papers to Barbara's house on Wednesday morning. She called me 90 minutes later, and the calm, controlled Barbara I had dealt with for months was completely gone. "What the hell do you think you are doing?" she screamed into the phone. "You cannot do this. We have permits. We have county approval." "You have permits based on false information," I said calmly. "My property was never part of Pine Ridge Estates. You built almost $1 million worth of facilities on my land without my permission. You never stopped us. You gave implicit permission by allowing the construction to proceed." "Actually, I told you multiple times to get off my property," I said. "I have recordings. You told me to take it up in court." "So here we are in court." "This is extortion," Barbara shrieked. "I will have you arrested." "Feel free to call the police," I said. "I have Deputy Morrison's number if you need it. I am sure he would love to hear about your $1 million construction project on someone else's property." She hung up on me. Over the next few hours, I got calls from 6 different HOA board members, 3 lawyers representing Pine Ridge Estates, and about a dozen confused homeowners who had started hearing rumors about the lawsuit. To the homeowners, I was sympathetic but firm. "I am sorry you got caught in the middle of this. You should never have been told you were buying access to these facilities. The HOA had no right to build on my property or to collect money for access to it." The most common question was, "But what about our deposits?" "That is between you and the HOA," I said. "They are the ones who took your money for something they had no authority to sell." Barbara tried to organize a counterattack. She held an emergency HOA meeting and pushed through a special assessment to hire a high-powered Las Vegas law firm to fight my lawsuit. Each household in Pine Ridge Estates, all 230 homes, got hit with a $1,200 emergency fee to cover legal costs. That did not make her popular. The injunction hearing was scheduled for mid-September. Patricia was confident, but she warned me that judges could be unpredictable in cases like this. Some might see the HOA's construction as improving the property and be reluctant to order everything torn down. Others might split the difference and try to work out some kind of compromise. The hearing lasted 3 hours. Barbara's lawyers argued that I had given implicit permission by not seeking an immediate injunction in March. They claimed I had waited strategically to maximize damages, which showed bad faith. They argued that the county permits, even if based on incorrect information, provided good faith protection for the HOA's actions. Patricia destroyed them. She presented my contemporaneous notes from March, showing that I had immediately objected and been told by multiple people, including law enforcement, that I needed to pursue the matter in court. She showed that I had hired her within days of the construction beginning, and that her advice to document everything was sound legal strategy, not bad faith. She presented the property records, showing clearly that my land had never been legally part of Pine Ridge Estates, and that the notices sent to the wrong address meant I had never been properly included in any proceedings. The judge, a no-nonsense woman in her late 50s named Judge Carolyn Park, was not sympathetic to the HOA. "Let me make sure I understand this correctly," Judge Park said, looking at Barbara's lead attorney. "Your client built extensive facilities on property they did not own, collected nearly $800,000 in deposits for access to those facilities, and has been collecting monthly fees of over $20,000, all without ever confirming that they actually had legal authority to do any of this." "Your Honor, the county permits," the attorney began. "The county permits were based on incorrect information that a basic title search would have caught," Judge Park interrupted. "Did anyone from the HOA actually verify ownership before beginning construction?" The attorney hesitated. "We relied on the county's designation." "That is not an answer to my question," Judge Park said. "Did anyone verify ownership?" "No, Your Honor," the attorney admitted. Judge Park shook her head. "I am granting the injunction. All boats and personal property must be removed from Mr. Webb's property within 14 days. The structures will remain pending a determination of ownership, but no one from Pine Ridge Estates or its residents may access the property without Mr. Webb's explicit permission." Barbara stood up in the gallery. "Your Honor, that is impossible. These families have nowhere else to store their boats on such short notice." "Then they should discuss that with their HOA president, who assured them she had the legal right to build these facilities," Judge Park said coldly. "We are adjourned." The aftermath was chaotic. 53 families scrambled to find alternative boat storage with only 2 weeks' notice in late September. Most of the marinas around Lake Tahoe were already full or closing for the season. Some people had to trailer their boats home and find storage facilities hours away. Others paid premium rates for emergency slip rentals at commercial marinas. The anger directed at Barbara was intense. She had collected their deposits, charged them monthly fees all summer, and now they were being evicted with nothing to show for it. The special assessment to fight the lawsuit added insult to injury. 3 homeowners filed a separate lawsuit against the HOA demanding refunds of their deposits and fees. Within a week, that lawsuit had grown to include 37 families. Barbara tried to stonewall them, claiming the HOA's insurance would cover everything, but the insurance company disagreed. Building structures on someone else's property without permission fell well outside their coverage. Patricia filed additional motions seeking a ruling on ownership of the structures themselves and demanding an accounting of all fees collected by the HOA. We argued that everything built on my property belonged to me, and that the HOA had essentially been stealing from both me and the residents by collecting fees for access to facilities they did not control. In late October, we got a settlement offer. The HOA would pay me $300,000, admit no wrongdoing, and I would grant them an easement to use the shoreline for 10 years with gradually increasing annual fees. Barbara presented it as a win-win solution. I rejected it immediately. Patricia filed a counteroffer. The HOA would pay me $795,000, the full amount of the deposits collected. They would transfer ownership of all structures to me without restriction. Barbara Hutchinson would resign as HOA president, and I would not pursue criminal fraud charges. That last part got their attention. Patricia had been researching Nevada's fraud statutes, and collecting money for property access you do not actually control could potentially be prosecuted as theft by false pretenses. It was a long shot, but the possibility of criminal charges scared the HOA's lawyers. Barbara refused to consider resignation. The HOA board met for 6 hours trying to find a compromise. In the end, the homeowner lawsuits made the decision for them. With dozens of families demanding hundreds of thousands in refunds, the HOA's reserves were completely tapped out. They could not afford to fight both me and their own residents. The settlement conference was held in early November. Barbara showed up looking like she had aged 5 years in 2 months. The board had forced her to attend, even though their lawyers had suggested she stay away. She spent the entire meeting glaring at me like I had personally betrayed her. "You played us," she hissed during a break in negotiations. "You knew from the beginning this was your property, and you just sat back and waited until you could cause maximum damage." "I knew it was my property because my grandfather left it to me in his will," I said. "You are the one who showed up with construction crews and built $500,000 worth of structures without bothering to verify you had permission. How is your failure my fault?" "You could have stopped us in March," Barbara said. "Instead, you let us spend all that money and collect all those deposits just so you could swoop in and steal everything." "I did not steal anything," I said. "You built facilities on my land. You collected money for access to my land. If anyone did any stealing, Barbara, it was you." She looked like she wanted to say more, but her lawyer pulled her away. The negotiations continued, and by the end of the day, we had a deal. The HOA would pay me $600,000, which represented the deposits minus some amount their lawyers argued had been spent on actual construction materials that improved my property. They would transfer ownership of all structures to me. Barbara would remain as president, but the HOA would implement new oversight procedures to prevent similar disasters. I was not thrilled about Barbara keeping her position, but Patricia advised me to take the deal. "You are getting most of what you wanted," she said. "If we push for criminal charges or force Barbara out, they might get desperate and drag this out for years." She was right. I agreed to the settlement. The structures were officially transferred to my ownership in mid-November. The $600,000 hit my account a week later, after the HOA took out an emergency loan secured against future dues to cover the payment. But I was not quite done. The residents who had paid deposits still needed resolution. 37 families had filed lawsuits demanding refunds, but the HOA claimed it could not pay because all the money had gone into construction costs and was now gone. This was a lie because I knew Barbara had been collecting monthly fees all summer that were pure profit. I made an offer to the suing residents through their attorney. I would refund 50% of their deposits directly, in exchange for them assigning their claims against the HOA to me. Essentially, they would get $7,500 each immediately instead of fighting the HOA for years hoping to recover $15,000. Most of them took the deal. They were tired of fighting, tired of the legal fees, and 50% back immediately was better than maybe getting everything back eventually. 31 families accepted my offer. I cut checks totaling $232,500 and received assignments of their claims against the HOA. The remaining 6 families decided to continue fighting the HOA directly. I wished them luck and meant it. Barbara had screwed them over as much as she had tried to screw me. With the settlement money, the claim assignments, and the structures themselves, I now needed to figure out what to do with 53 boathouses on my property. Tearing them down seemed wasteful. They were well-built, functional, and could generate income. Patricia suggested I look into running them as a legitimate rental operation. "You own marina facilities on prime Lake Tahoe waterfront," she said. "Do you have any idea how valuable that is? You could rent those slips commercially for $800 to $1,000 per month easily." She was right. I spent December researching marina management, talking to insurance brokers, and setting up a proper business structure. I formed an LLC called Webb Lakefront Marina, got proper permits and insurance, and hired a local boat maintenance company to handle day-to-day operations. In January, I started marketing the slips. The response was overwhelming. I had the 53 slips leased within 3 weeks at an average of $900 per month. I instituted reasonable rules, hired a part-time manager, and basically turned Barbara's nightmare into a profitable business. The real bombshell came in February. One of the residents who had continued fighting the HOA independently came to me with interesting information. His lawyer had subpoenaed the HOA's financial records and discovered something shocking. Barbara had not deposited the $795,000 in deposits into the HOA's accounts. She had created a separate LLC called Pine Ridge Marina Management and deposited the money there. The monthly fees had also gone into this separate company. Barbara had essentially been running a private business on my property while pretending it was an HOA amenity. The construction costs had been paid by the HOA's reserves through the special assessment and regular budget allocations, but the deposits and monthly fees had gone into Barbara's pocket. I shared this information with Patricia immediately. She contacted the Washoe County District Attorney's office. They opened an investigation into Barbara's finances and discovered she had funneled over $1 million through Pine Ridge Marina Management over the past year. The deposits, the monthly fees, and even some of the special assessment money had gone into her personal business account. The DA charged Barbara with theft, embezzlement, fraud, and racketeering in March. The racketeering charge was based on her systematic scheme to defraud both the HOA and the residents through her fake company. She was arrested at her home early on a Wednesday morning, and the local news covered it extensively. The HOA board immediately placed Barbara on administrative leave and hired a forensic accountant to untangle the mess. They discovered she had been skimming money from HOA accounts for years through various schemes, but the marina project was by far the largest. The total theft was estimated at over $1.3 million. I actually felt bad for the Pine Ridge Estates residents at that point. They had trusted Barbara to manage their HOA, paid their dues faithfully, and she had been systematically stealing from them the entire time. The board started proceedings to remove her permanently and worked with the DA's office to try to recover the stolen funds. Barbara's trial was scheduled for October, but she accepted a plea deal in August. She pleaded guilty to theft and fraud charges in exchange for the racketeering charge being dropped. She was sentenced to 6 years in prison and ordered to pay full restitution to the HOA and the affected homeowners. The judge also permanently banned her from serving on any HOA board in Nevada. The restitution order was nice in theory, but Barbara had spent most of the money. She had renovated her house, bought a new car, and taken expensive vacations with what she had stolen. The HOA and residents would likely recover only a fraction of what they had lost. For my part, I ended up in a surprisingly good position. I had received $600,000 in the settlement, gotten ownership of facilities worth at least $500,000, and now had a marina business generating over $48,000 per month in rental income. After expenses, insurance, and management costs, I was clearing about $30,000 a month in profit. I refunded the 31 families who had assigned me their claims against the HOA as part of Barbara's restitution. They each got their full $7,500 back from Barbara's seized assets, which meant they ended up being made whole. The other 6 families who had kept fighting got their money back from the HOA's insurance after the criminal conviction proved the board had been negligent in its oversight. The Pine Ridge Estates HOA underwent major reforms. They hired a professional management company, implemented strict financial controls, and created a resident oversight committee. The new board president was a retired accountant who seemed genuinely committed to transparency and responsible governance. I occasionally saw former slip renters around the lake. Some were still angry about the whole situation, but most had moved on. A few even applied to rent slips at my marina, though I politely suggested they might prefer a different facility given our history. The best part of the whole saga came in November, almost 2 years after Barbara first showed up on my dock with her clipboard and her hard hat. The Webb Lakefront Marina had become one of the most popular rental marinas on the Nevada side of Lake Tahoe. I had expanded services to include boat maintenance, winter storage, and even a small watercraft rental operation for tourists. I was down at the marina on a Saturday afternoon helping the manager prepare boats for winter storage when a young couple came by asking about slip availability for next season. They were new to the area, they explained, and had just bought a house in Pine Ridge Estates. "We heard this marina has a pretty crazy history," the husband said. "Something about an HOA president building it illegally." "Something like that," I said with a smile, "but everything is legitimate now. Proper permits, proper insurance, and definitely no HOA involvement." "That is refreshing," the wife said. "Our HOA is actually pretty good now, but we heard horror stories about the previous president." "I might have heard a few of those stories myself," I said. They signed a lease for a slip starting in April. As I watched them walk back to their car, I thought about Barbara in prison, about the residents who had been caught in the middle of her schemes, and about the incredible chain of events that had turned my quiet lakefront property into a thriving business. My grandfather had always said the property would take care of me if I took care of it. He had been right, just not in any way either of us could have predicted. The land he had loved and protected for 50 years had indeed provided for me, though it took an HOA president's massive fraud and overreach to make it happen. I sold the main house 2 years later and built a new modern home on the southern part of the property, away from the marina operations. The business continued to grow, and I eventually expanded to offer sailing lessons and guided fishing tours. What had started as Barbara's illegal construction project on my land had evolved into a legitimate, successful business that served the Lake Tahoe community. Sometimes I wonder what would have happened if I had successfully stopped the construction back in March when Barbara first showed up. I would have saved myself months of stress and uncertainty, but I also would have missed out on an incredible opportunity. Patricia's advice to let them build and document everything had been risky, but it had paid off beyond anything I could have imagined. The last I heard, Barbara was working in the prison laundry and would be eligible for parole in 4 years. The Pine Ridge Estates HOA had fully recovered from the financial damage she caused and was actually running quite well under professional management. The residents who had lost money in Barbara's scheme had all been made whole through various restitution and insurance payments. As for me, I was living the dream my grandfather had always envisioned for the property. It was productive, beautiful, and serving the community. The fact that it took an HOA's illegal construction project and a corrupt president's fraud scheme to get there was just one of those strange twists that make life interesting. I still laugh sometimes when I walk down to the marina and see the boathouses that Barbara built on my property without permission. They were supposed to be her legacy, her grand vision for Pine Ridge Estates. Instead, they became the evidence of her crimes and the foundation of my business. There is probably a lesson in there somewhere about hubris and overreach, but mostly I am just grateful for how everything worked out. The dock where I first saw that construction crew pulling up with all that lumber is still there, preserved as part of the marina's main entrance. I sit there sometimes in the early morning with my coffee, watching the sun rise over Lake Tahoe, and I remember that moment when I realized my life was about to get complicated. I had no idea just how complicated it would become, or how well it would turn out in the end. Barbara had shown up on my property with her clipboard and her permits and her absolute certainty that she knew better than everyone else. She had built 53 boathouses on my lakefront without permission, collected nearly $1 million in deposits and fees, and acted like she owned the place. I had let summer end, documented everything, and then evicted everyone and kept the facilities she had built with money she had stolen. In the end, justice had been served. Barbara was in prison, the residents had been made whole, and I had turned an illegal construction project into a legitimate business. The property my grandfather had loved was thriving, the community was being served, and I was making a good living doing something I enjoyed. Sometimes the best revenge is not revenge at all. Sometimes it is just patience, documentation, and letting someone's own actions catch up with them. Barbara had been so confident, so certain she could bulldoze her way through any obstacle. She never considered that the quiet guy watching from his deck might be documenting every step, building a case, and waiting for exactly the right moment to act. The Webb Lakefront Marina continues to operate successfully to this day. I have no plans to sell or retire anytime soon. The business is stable, profitable, and genuinely serves the Lake Tahoe boating community. What started as an HOA's illegal overreach became my livelihood and my legacy. And every time someone from Pine Ridge Estates asks me how I ended up owning a marina, I tell them the whole story. I tell them about Barbara showing up with her construction crews, about the months of documentation and waiting, about the lawsuit and the settlement, and about discovering her embezzlement scheme. I tell them everything because it is a great story, and because it is a cautionary tale about what happens when HOA boards operate without oversight and presidents think they are above the law. The property my grandfather left me was supposed to be a quiet retreat, a place to escape the stress of Silicon Valley and enjoy the natural beauty of Lake Tahoe. Instead, it became the center of a legal battle, a criminal investigation, and ultimately a successful business venture. Life rarely turns out the way you expect, but sometimes the unexpected turns out better than anything you could have planned. I raised my coffee cup toward the boathouses stretching along my shoreline, a silent thank you to Barbara Hutchinson for her spectacular failure and her unintended gift. Then I went back to work, managing the marina she had built, making money from the facilities she had constructed, and living the good life on property she had tried to steal. Justice, profit, and a beautiful Lake Tahoe sunrise. It did not get much better than that.